I believe that as creatives, as the people who I represent, the most sacred place you all have is that space between when the idea comes to you and like before you go and tell it to the world. A lot of times we get so excited about the idea, the prospect of it, how big it could possibly be. And even moving forward and saying, I'm going to bring this to fruition. And then filing a trademark application or launching a business and then getting a cease and desist letter or threats of being sued can take so much wind out of your sails. And it's honestly really scary. It's really scary to get a letter like that. And I think it can affect someone's creativity and their confidence. And we need confidence and boldness as entrepreneurs. And for me, I think on that particular level, it's also about shielding that and protecting that. And I like to say I put a legal cloak of protection around my clients because I want them to be able to build their business with peace of mind. And it's really hard to get peace when you don't know if someone's going to steal something from you or if you did something right. You'll always be worried about that.
You're listening to the Black to Business podcast, an educational podcast providing Black entrepreneurs with the tools and resources to start and grow their businesses. We chat with vetted Black entrepreneurs, thought leaders, and business owners as they provide tips and resources to help take your business to the next level. I'm your host, Monique T. Marshall. Welcome back. So first things first, if you're usually multitasking while listening to podcasts, take my advice on this one and please don't. Because today's episode is oh so special because it really feels like a masterclass. I had out my notepad and all. And we were intentional about today's topic being broken down because we wanted it to be digestible. And our special guest today delivered. We're talking about a topic that we believe should always be the foundation of your business idea and one to be carried throughout your entrepreneurial journey. We're discussing protecting your smarts and trademarking. So I'm so excited about today's guest, attorney Ticora Davis, who is the founder and CEO of The Creators Law Firm. She's an attorney, author, and speaker known for her work in advocating for more holistic, inclusive, and ethical legal representation for Black women and Black creatives. So I won't make you wait any longer. Let's bring on attorney Ticora Davis. So Ticora, thank you so much for being on the show. I'm really excited about today because I know that this is a topic even I want to learn more about, but I know my audience would very much appreciate. So welcome to the show.
Thank you so much for having me. I'm happy to be here.
Of course. So today we're going to be talking about the do's and don'ts of trademarking. But before we jump into that, if you could just tell me, my audience for who don't know you, a little bit about yourself and what is it that you do in your business and how you got started.
Sure. Well, I am attorney Ticora Davis. I'm the founder and CEO of The Creators Law Firm. We have the distinct honor of helping legacy-driven entrepreneurs protect their brand so they can grow their business with peace of mind. We represent some of your most favorite Black and woman-owned brands with respect to protecting their smarts, their intellectual property portfolios, and all of the amazing things that they are creating and putting into the world. In terms of how I got started, it is a long story. I don't mind telling, but in short, I've always said I wanted to be an attorney ever since I was a little girl, but I was very shy growing up, and I kind of chose another path. I began to pursue science, and I thought I wanted to be a doctor. I thought that would make my parents proud, and so I do have a biology degree, but I'm very thankful for pursuing that degree, even though I don't really use it, because through that educational path, I was able to discover intellectual property law because I worked with plant patents. And that's where I understood that there is a way for these two worlds, meaning science and law, to meet. And there is an opportunity for me to pursue law school with my unique background. And it would actually make me a very unique student and help me stand out from everyone else. And so once I graduated, I ended up going to work on the Hill for Congresswoman Marcia Fudge. And I was her legislative assistant, a legislative correspondent and staff assistant. And there I was able to staff her briefly on the Science and Technology Committee while also handling a lot of constituent correspondence. And that was a wonderful experience because it helped me understand damage control, how to deal with people who are not always happy,
yes.
Manage people. So, every experience you have, you can carry that with you to the next level. And while I was there, I said, wow, I love the law. I fell in love with the law there by working in the nation's capital and seeing how laws were made and thinking, wow, some of the people who have the most power on the Hill actually have a legal background. I noticed that. And so then I said, okay, I do want to pursue law. Perhaps I will return and maybe, counsel the congresswoman or a member of Congress. But while in law school, I began to discover there was more to intellectual property law than just patents, which was my initial thought. Maybe I could pursue that. And that's where I discovered trademark law. I watched I don't know who she is, but she used to work at Coca-Cola and she was an intellectual property lawyer for Coca-Cola and she was a Black woman. And I saw her give a lecture. And from the moment I saw her speak on the computer screen about what she did, I was amazed. And I said, that's what I want to do. I want to be a trademark attorney. This looks so cool what she does, because I was taking this course on patents. And of course, they dive into other areas of intellectual property law. And I was like, I don't want to do patents. I want to do that. And it was just that one moment that changed everything. And so very thankfully, I began to pursue it. I graduated, got a job as an intellectual property analyst, and I worked at a company where individuals would submit their ideas and I would do patent research on it to see if it was eligible for patent protection. And I was able to see different inventions at different stages of development, some that were in the initial process stage, others that were in the prototype phase, others that were going to market. And what I understood there was that, one, again, I didn't want to do patent law, but I fell in love with the inventors and the creatives. And I began to understand what makes them tick. What is their mindset? Why are they so passionate about their unique creations? And so, unfortunately, got laid off from that job because they were downsizing. And then actually, my husband and I, we got pregnant. We were really excited about having our first child, even though I'd just been fired. True. Got a job with a local law firm. And I thought, this is my dream job. This is an entertainment lawyer. I can work with artists. This is my foot in the door. And this was in 2016 when I got this job. And it was really terrible. It was a very toxic and abusive work environment. So while working there, I faced a lot of yelling, cussing at me. And I'm, obviously pregnant, as well as the other female staff by the lead male attorney. I didn't learn anything about practicing law there because he treated me as a secretary. Wow. But, and once I had my child, he called me on the phone and he told me, I no longer think you're fit for the success of this firm. I think you need to stay home and focus on healing your body and get over your pregnancy brain. Wow. It was like somebody punched me in my gut. I'm holding my 10-day-old baby in my hands and this person telling me basically my son is going to be my downfall, that I'm not going to be successful because I'm a mom. But again, very thankful for that experience, not for the abuse, but for the revelation that that was the option for many people. Before I created a new option in terms of employment. It's very difficult to get into this area of law. Of all of the attorneys in the United States, only 5% of them are African American. And as it relates to who practices intellectual property law, only 1.9% of attorneys are African American that practice the type of law that I do. So when you see those sobering statistics, you understand that there are not many minorities, let alone women, who practice this type of law. And unfortunately, that was one of the options to go and work for that man, I was going to say gentleman. But I realized that I was destined to create another alternative. And I did so in January 2017. And, now 4 years later, I run a Black-owned, woman-powered law firm. I have about 9 employees at this time. All of them are women. We certainly welcome men to come work with us if they can get with the program. But it's just amazing to have a business where I get to create jobs and better jobs. And not only that, serve entrepreneurs who are Black entrepreneurs and women entrepreneurs, because it's not been very long in this country that both Black individuals and women have been able to own property, let alone intellectual property. So we're really proud of the work that we have the honor to do, because we're able to help others protect their legacies, which has often been robbed in this country because of our community's ignorance. But, I didn't learn about intellectual property until I was 25 years old in a science lab, and now other entrepreneurs are finding out about the power of their intellectual property in their late 20s or 30s. And my job is to make sure that with my platform, I'm able to educate my community and empower them with the legal knowledge that they need to protect not only their brand, but to empower their fellow brother and sister as it relates to what they know. So that's my story. And I'm also on my soapbox now. So I'm going to get down and I'm going to let you ask another question.
I love it. I mean, my face over here is like a church woman, like amen, corner, all of that. And I'm just like, how dare I say Ticora? I have to rephrase everything and say Attorney Davis from now on. So that's how we're going to run this whole thing. Laid it out. You really did. And just such a powerful story. I'm pretty sure many people who are listening can relate and find inspiration, because one of the things you mentioned is, that 1% intellectual property. Oh my God, I did not know that.
Yeah.
And 2, the representation of you just hearing someone didn't even know who he was, inspired you to change your pivot. So that's amazing, Attorney Davis.
One person, sometimes one person walking in their purpose can change our lives. And I was so thankful for her, because she came in and she was dressed to the nines. She was beautiful. Like, I was looking at her and I was like, oh my gosh. And she was speaking and I'm like, this is so cool. I lit up. And I was just thankful that she came in and she did that guest lecture.
Yes, I love it. I love it. So I'm so excited about this conversation, because I know that, what you're doing is so amazing. And I knew you was the perfect person we wanted to have on the podcast to talk about this. So let's get into it. So my first question is, what is trademarking? And another thing that you mentioned I want you to expound on is, when it comes to trademarking versus patenting, breaking that down, because I know you have a background as well in that.
Oh, yeah. I'm going to roll it back and I'm going to give you all a legal IP 101. So that's what we're going to do. And after this, we're going to be experts. Okay. So I like to think of intellectual property as an umbrella. And I like to compare it to the umbrella of criminal law. So underneath the umbrella of criminal law, you might have breaking and entering, or you might have a speeding ticket, right? Like, they're both crimes. They're different types of crimes that fall underneath the umbrella of criminal law. Well, similarly, intellectual property is its own umbrella. And underneath that umbrella, you have things like patents, copyrights, trademarks, trade secrets, and personality rights. Personality rights is your right as an individual to control how your name, your image, your voice, your likeness is used in a commercial basis, meaning how somebody can make money off of your overall aesthetic. A lot of times we see this when it comes to celebrities and, people using their name, their likeness, and endorsements to obviously, get either attention, traffic, money, media, sell products, etc. Then we have trade secrets. These are juicy proprietary secrets. That could be like your secret sauce, your special formula, and how you maybe run your coaching program. It could be your unique frameworks and worksheets. It could even be maybe your secret recipe for your soap, or maybe you're a baker and there's a unique way that you do that. And so you want to make sure that when you get new employees or independent contractors and they may become privy to this information, you can protect it. And the best way to do that a lot of times is by a trade secret, or treat it as a trade secret and protect it via a non-disclosure or confidentiality agreement. I think the most famous example of this is how they have that Coca-Cola formula locked up in the vault in Atlanta. That's their trade secret. Because other types of intellectual property, such as copyrights and patents and trademarks, you have to actually disclose information. So it's best not to say, okay, I'm going to write a book and I'm going to write my secret formula and I'm going to copyright it, because it's searchable and then everybody can see the recipe, and that defeats the entire purpose. So you protect that type of stuff via really airtight contractual agreements. Okay. Then we move on to copyrights. A copyright protects a unique literary or artistic work. The best way to explain that is like the books that people write or poetry. This can also extend to podcasts, photography, videography, some unique computer coding, as well as artistic and graphic design. The copyright protects how, also songs as well. So the copyright protects how that is actually, whenever you put it in a form, in a medium, as we say, that people can experience, the copyright can attach to that. Now, copyright applies automatically from the moment that you take the picture in your phone, like you snap it, you own the copyright to that photo. But what we encourage is strategic registration of your unique copyrighted works, because nobody knows that you own the copyright. So you own the copyright to tons of things, but in terms of who is the legal owner, there's no record of that a lot of times, unless you file that with the United States Copyright Office. That is a completely separate office from the United States Patent and Trademark Office. So a patent is where you can get unique protection over an invention, something that you create. It has to have, a utility patent has to have some sort of function. So this might be as complex as the engine of a car or the circuitry in a phone, or it can even be something like a mechanical pen that you click up and down. There can be patents on all of those unique things that help things function. There are also other types of patents, such as a design patent that can protect the unique artistic design of product packaging. So the Coca-Cola bottle, or even the Peeps, that nasty marshmallow candy that I hate, that has a design patent on it because the product packaging is unique. But the thing about design patents is that they only have a lifespan, I think, of about 15 or 16 years. And so I'll get back to that in a second when I relate it to a trademark. And then the other type of patent you have is a plant patent. This is what I was first introduced to as someone who did plant physiology research on genetically modified tomatoes. And so there were things that you can do to manipulate or change or transform I would say a God-made or a naturally made plant and make it something that is man-made. So you can have a plant patent, but it must be on something not that is naturally occurring, but you made some sort of modification to it. And finally, where we get to my beloved trademarks, trademarks are unique names, unique names, taglines, logos, and in very rare cases, a trademark can be a sound, a scent, and a color. But no matter what, the whole function of a trademark is to help you identify a brand as the source of the product or service. So when I see that unique green lady and she looks like a mermaid weird fish thing, I know that's Starbucks. I don't even have to see the word Starbucks. When you see her face, she helps you identify the source of the coffee, right? If you look at the swoosh on someone's sneakers or someone's shirt, you're like, oh, that identifies the source of this product, which is Nike. So your trademark should help people get eyes on your brand, no matter if it's your name, your tagline, or your logo. Trademarks are the only type of intellectual property that can last in perpetuity. And what do I mean by that? Forever, ever. Quoting Andre 3000. As long as your brand and your company is using that logo mark or using that tagline or using that unique business name, it can elapse or last for centuries. The other amazing thing about intellectual property is that can be passed down in a will. It's just like a car or a home that someone leaves someone as a part of the inheritance. These types of assets, intellectual property, can also be left to your children and your children's children. So let me get off my soapbox again. I get so excited about it. But that's the different types of ways that trademarks can work. I also forgot that you can actually get a trademark on packaging as well. And so some people will take a strategic route, get a design patent on their unique logo, on their unique product packaging or whatever, and make sure they create marketing around it. Because remember, your trademark has to help identify your source of products and services. So you have to make sure the public can say, when I see the Nike swoosh, it helps identify the brand. Or if I see the Coca-Cola bottle, I know it's Coca-Cola, right? And so that's what people do when they take the strategic pathway of saying, let's get the design patent first. Let's create unique marketing to make sure that the public is educated about this. And then from there, once they built up public awareness, that can be used as evidence to get a trademark on the product packaging. All right. So that's like the skinny on that, your trademark masterclass on the different types of intellectual property.
Okay, so we're taking a collection because my pen could not move fast enough. And I'm like, oh my God, I didn't even know that. So that was a great masterclass. I'm with it. I love it. And one of the things I also know that you mentioned, I was just catching up on your Instagram because you provide so much knowledge there, is you mentioned the likelihood of confusion. You talked about the Lil Nas and Nike situation, which was a great example, too, of you possibly suing them. So,
yeah, there are different things, so I'm not sure when you'll be listening to this or if you even heard of the Lil Nas X situation, but Lil Nas X is a rapper. He created a new song that was quite controversial. A lot of people had a lot of discussion around it. But what he decided to do was partner with a brand. I believe their name is Mischief, and they are known to push the button when it comes to sneakers and different type of street apparel and things like that. So the company purchased Nike Air Maxes, I think the 97 Nike Air Max. Then they customized it in a way that basically had different satanic symbols on it, or even some biblical symbols as well. And they also put red dye in the sole of the shoe, and then they infused it with 1 drop of human blood. I'm sharing all of this to say that when the brand released the shoes and they sold those shoes for $1,018 and they only sold 666 pairs, the public assumed that this was a partnership in collaboration with like an official partnership with Nike. And so people thought, okay, wow, Lil Nas X, Mischief, and Nike have partnered together to create this controversial shoe. And that was kind of how the promotions and the marketing surrounding it on behalf of those parties was put out. And so because of this, many individuals saw it and then they called for a boycott of Nike, said that they couldn't believe that Nike would do this, and et cetera, et cetera. And it also just looked as if the shoe was a unique release from Nike. And so what happened was people began to call for the boycott. And ultimately, as I said, your trademark is one of your most valuable business assets, because when people think of unique names or a name at all, you're either going to have a positive association with the name or you can have a negative association with the name. So people defend the goodwill, the value of the trademark vehemently. And so when Nike started to see the public outcry, the calls for a boycott, people being really, really, really shocked, they realized, oh, wow, we have to show to the public that we're not affiliated with this. We are going to sue them for trademark infringement. We're going to sue them for trademark dilution, which means you diluted the value of my brand based on your actions. Because they sue them for unfair competition. You know, you purchase shoes and they might be $100 or something. You make a few modifications and then you turn around and you sell them for over $1,000. They're suing them for that. And then they also, I believe, sued them for something else. I can't remember all of the things, but that can also happen. So some people feel like, well, if I purchase something, I can modify it in any way, shape possible. I should be able to do whatever I desire with my purchase. And in theory, that is true to a certain extent. You can modify things for your personal use, but then when you begin to commercialize it as such a manner as what they've done, it could potentially be legally actionable. And the brands are going to do what they need to do to protect their trademarks because they understand, you know, this brand has staying power. It's been around for decades. So they're going to make sure that you're not going to affect their bag, so to speak.
Yes. And I'm sure like a lot of people, that is, you know, not even knowing all of the ways that they can affect a brand. So I really want to address the key role of someone like you, because you are the expert, Attorney Davis. So what is the role of an attorney during this process and why are they essential for the trademarking process?
Yeah. So you don't have to hire an attorney to file your trademark. Now, if you don't do that, we will be around if you get it refused or if you need help getting it across the finish line. Because in this country, everybody has the right to represent themselves, even when it comes to civil matters. And we can even see that like in the criminal courts where, you know, you watch TV and the guy's like, I'm going to represent myself. I'm firing my attorney. You can do the same thing as it relates to trademarks, that trademark process. I think that an attorney is a great component, an essential tool, an asset that can support you because there's just a lot of stuff that I know that everybody else doesn't know. For example, I know that there are, and I like to call them my dirty dozen, but I have a list of names and I'm actually building upon it. But I did a webinar and I talked about the 12 names that you should not trademark. Because even though you may search the trademark office website and say, oh, there's no trademark that's available, I can get this name protected. One of them being case in point, Hue, H-U-E. A lot of people are using that playfully in their names, their taglines, but Kaiser Roth Corporation owns the mark Hue. And most of us will remember this, especially me, like being a little girl and going into JCPenney or Belk growing up, and they had all of the hosiery and the pantyhose. They that mark for that, not just hosiery, but also clothing and apparel. They don't care if you add words before, after, Hue, or whatever. They're not going to allow you to trademark it. But someone who doesn't have that requisite knowledge, they could just search and say, okay, my trademark is going to be in Hue Living or something like that. And what they'll think is, oh, there's no other trademark out there that has that. I'm free. I can file my trademark application. But other skilled attorneys know there are certain brand names to avoid unless you want to get sued. So attorney can really come into play and really support you. Also, I think people need to get in the habit of really fully adopting the title, if they can, of being a CEO and making sure that you are able to leverage other individuals on your entrepreneurial journey who have skill sets that you may not have. And so that is also something where someone can handle the process for you and you don't have to worry about anything. The trademark process is not overnight. And I'm strictly speaking about filing a trademark on a federal level, because it can take about a year to a year and a half, sometimes longer, to actually have your trademark mature to registration. there are lots of bumps and loops and turns on the journey that can often be remedied or quickly rectified with a call or, a simple form. And sometimes things are more complex, and it's great for an attorney to come into play and help. So I think that an attorney can assist when it comes to expediting the process. We really can't make it move faster, but we certainly can make sure your trademark application is well drafted. We can make sure that you get the widest scope of protection for the least amount of money. And then you actually have a human that you can speak to along the process so you can have that support for the long haul. So those are just a few benefits to having a trademark attorney. And I think, for me, it's very much, in my opinion, it's a spiritual thing too. Like, I believe that as creatives, as the people who I represent, the most sacred place you all have is that space between when the idea comes to you and before you go and tell it to the world. A lot of times we get so excited about the idea, the prospect of it, how big it could possibly be. And even moving forward and saying, I'm going to bring this to fruition. And then filing a trademark application or launching a business and then getting a cease and desist letter or threats of being sued can take so much wind out of your sails. And it's honestly really scary. It's really scary to get a letter like that. And I think it can affect someone's creativity and their confidence. And we need confidence and boldness as entrepreneurs. And for me, I think on that particular level, it's also about shielding that and protecting that. And I like to say I put a legal cloak of protection around my clients because I want them to be able to build their business with peace of mind. And it's really hard to get peace when you don't know if someone's going to steal something from you or if you did something right. You'll always be worried about that.
Yes, I can definitely relate to that because now that you say that, I remember it was about 3 o'clock in the morning. I got this message once a couple of years ago, and it was someone using Black's business name, and they reached out to me to partner. And I'm like, no, you have to stop, a cease and desist. And I remember jumping up, reaching out to an attorney. And like you said, it did the creativity, just handling that process, it did drain it. So yes, but thankfully I had it trademarked.
Good for you.
Yes. And so speaking about trademarking and, when to do it, I think my audience, they are in their idea to 3-year mark phase and looking to figure out where should they allocate their resources because a lot of people are bootstrapping. So when would you say someone should start the trademarking process?
Honestly, you should start the trademarking process before you launch your product or program or very soon thereafter. I know that some people are bootstrapping, so I love to give these resources. So there are trademark clinics run by law schools across the country. You can find them on the USPTO's website, and they will either do your trademark for free or all you have to do is cover the cost. And some of those programs will actually cover the cost of filing for you. So that's a wonderful place to go if you're saying, gosh, I really need support. This is something I'm really passionate about, but I don't have the capital to invest in an attorney. And I completely understand that. And so I think law school clinics are the perfect option for people who are in your audience because you have a team of sometimes dedicated, 3 to 5 dedicated law students working on your trademark application under the supervision of a trademark attorney or a business attorney. And so you have students diligently working. They want to do a good job because they want to get a good grade. And you also have the opportunity to work. And so looking for those entrepreneurial clinics is definitely a game changer. I would not recommend filing on your own if you can avoid it, especially if you can get support from a law school clinic. Another option, if you're bootstrapping, is to reach out to your state bar. Every single state bar encourages attorneys to provide pro bono legal work. And some of us are encouraged to provide 25 to 50 hours of pro bono or low bono, meaning no cost or low cost free legal work every single year. And so in North Carolina, there is a program called the NC LEAP program, Lawyers for Entrepreneurs Assistance Program. And there are attorneys who volunteer their time to file patents and file trademarks and file copyrights on your behalf for free. And so those are great options. If you are bootstrapping and you know this is something you need and you don't have the capital, go to a licensed professional or go to a certified program. At least try that first before you try to do things on your own, because you won't be able, you don't have to pay and you're still getting great service.
Awesome. So yeah, we're definitely going to put those resources in the show notes. So thank you for mentioning those. And the other question that I have, Attorney Davis, is so one of the things is we want to avoid as many issues as possible, especially like you said, when starting up. So are you protected after you trademark? And what are some of the legal issues that people should avoid?
You said, are you protected after you trademark?
Yes. Is your business protected? So
So here's the thing, like people think when they get a trademark, it's magically going to keep people away, right? And we already heard from your own example that you had a trademark and someone was still using the name and you were able to leverage an attorney to help protect your brand. The trademark is an effective tool, I would say a weapon that you can use in your business. So having a federally registered trademark, meaning you have nationwide protection to exclusively use this name in connection with the unique products and services outlined in your trademark application, doing something like that, like having that in place will help you be able to defend the brand in the event someone does infringe on your intellectual property. It's not something that will always automatically stop people, but it is something that you can leverage to make sure that people are not going to come up and use things that are not, really within the scope of their rights. For example, if you have a federally registered trademark and someone else tries to create a confusingly similar Instagram or Facebook profile, and they begin to offer the same or similar services as you, then you can actually file an infringement form with either any of the social media platforms to get that removed. If you do not have the trademark, you will not be able to get those profiles removed. And so that is so powerful because instead of you allowing someone else to build up a platform, you'll be able to stop that because you're saying, hey, I'm actually the legal owner of this mark. That is evidence. That trademark certificate is evidence that you have to defend the brand. So I would say that, you need to also have a plan in place to not only defend the brand, but you also need to be thinking about expansion. So, for example, I have, a wonderful, I'll just say it, I love my trademark for my law firm. It's really powerful. But when people see the name The Creators Law Firm, they automatically know, oh, she's a lawyer for creatives. This is the lawyer that I need. And it helps with marketing as well. And so I've actually had a few attorneys try it, and I'm like, how are you a trademark attorney using my brand name? Let's not do that, But I'm strategically expanding my intellectual property portfolio, meaning I'm creating different trademarks and different products and services that kind of play off of The Creators Law Firm to make sure that no other attorney can come in and try and attempt to trademark a confusingly similar name. For example, I have The Creators Law Firm, The Creators Lawyer, The Creators Law Lab. Right. So I'm making sure that I continue to expand on my trademark. And this is particularly important if you have a descriptive trademark like I do. If your trademark literally describes either your product or your service or even the community that you serve, you need to really think like, okay, well, how am I going to make sure that nobody else comes in here and starts creating something that's too similar to mine? Another thing that we're doing is one of my associates, we filed a trademark for The Creatives Lawyer because other attorneys were trying to do that. And I'm like, I use The Creators Lawyer for speaking engagements, and I've been using that exclusively since 2017. And you're not going to come in here and try to change a few letters and use the name because they sound almost identical when you speak them out loud.
Yeah. Well,
go ahead.
That's interesting because to me, I have seen where they're in the same field. Now, I don't know everything, but they're in the same field and their names are similar. Well, I wouldn't say the same field, but they're in similar industries. Their names are similar, but they kind of offer different things. But you could get confused. So is that could be an issue with who used it first?
So that really depends on what product or service are they offering, because it may be an indication of what I like to call brand twins. So I've kind of coined that term where you have like two brands and they have the exact same name, but their products and services are different. Here are examples of brand twins: Dove chocolate, Dove soap; Delta Airlines, Delta faucets; Pandora jewelry, Pandora music, right? All of these are brand twins. So they have the exact same name, but their products and services are so dissimilar that people aren't going to be like, yeah, I'm going to go pick me up some Dove chocolate and walk down the soap aisle and get confused. Because if that happens, we got bigger problems, So, sometimes it's okay. Other times people just fail to police and protect their brand. And so then what happens is you can actually lose exclusivity over your trademark. This is what happened with Kleenex and Escalator. Escalator actually used to be a brand of escalators. Like it used to be a brand of moving stairs. But then when other companies created moving stairs and moving platforms, people in the public just began to call all moving stairs escalators. And instead of Escalator, the company, protecting their brand, that name began to lose its weight. It began to become diluted. And then what happened was it's genericide. It's kind of like homicide. Yeah. It became generic and they lost their trademark rights. The same thing I think happened to Band-Aid because now everybody says, okay, well, you can just put a Band-Aid on it. Band-Aid is actually the name of a company. They have a trademark on the logo, but they have lost the right to exclusively use the word Band-Aid as it relates to those things.
Wow. So that's a good point, because for people who are listening, and myself included, how are you going to stay on top of these things? What advice do you have for people to stay on top of these things?
Great question. I have like my company, my firm, I have some of my clients and we have trademark monitoring services. So if the client says, okay, we filed this trademark, we monitor the trademark database to see if anybody else is attempting to file trademarks that are confusingly similar. And so what will happen is I will get alerted to people who are attempting to file trademarks that are too close. So I got an alert on one of mine and I can file what's called a letter of protest. So it's like right after they file the application, I'm like, hey, I want to bring to the trademark examining attorneys who works for the trademark office, I want to bring to your attention my entire intellectual property portfolio, because you need to make sure that you're looking at my trademarks when you're analyzing whether or not you're going to let this one through. So that's one way you can stop a trademark application, by filing a letter of protest. The other thing that you can do is you can also formally oppose a trademark before it actually matures to registration during the publication period. So that's another option that you can pursue as well. Wow. And in terms of just staying on top of it, sometimes something as simple as doing a Facebook search or a Google search or following your unique, I follow all of my hashtags on Instagram. So that's sometimes how I find like, oh, another attorney is using creator's lawyer. No, ma'am, no, Sam. You're not going to use hashtag protect your smarts, hashtag creator's lawyer, because when people search those unique hashtags, that's supposed to help you identify my brand, not theirs. And a lot of times there's some younger attorneys and I politely share with them, hey, I just want to let you know, I had one who was calling herself the creator's lawyer. And I said, ma'am, hello, how are you? I don't know if you're aware, but I'm attorney Ticora Davis. I've been using this mark exclusively since 2017. Please remove that from your bio and cease and desist using these things. So sometimes as a professional courtesy, I'll just sometimes you can just send a nice message. Now, yeah. I just say I do that because, especially if you have trademark rights to that unique thing, right? So I just send a nice message and almost all of my colleagues have been quite kind.
I like that. Just a little nice nudge. And then if it doesn't work, next steps. But that's
you're like, okay, well, man, I got to bring the pain. Okay, if that's what I got to do, then I got to do that, because I know, like, for me, I'm like, this brand is going to help take care of my grandchildren. You're not going to steal out of my baby's mouth or my grandbaby's mouth. That's what you do.
I like the way you put that. So I just, even listening and learning, I think, like you said, sometimes people need to step into the CEO role. And that's one of the things that we encourage here at Black to Business, is for people to step into that role and work on their business, not in their business at all times. So, of course, people are listening. They're like, oh my God, how much is this going to cost me? Like, what are the legal costs of, looking for an attorney to do these things for me? Because it seems like a headache. What are some of the budgets that you feel that people should set for these things?
Well, I'll say this: good attorneys or real attorneys cost real money. So we gotta remember that, right? So, so there's the thing. So I would say a lot of times I've seen some of my colleagues and they sell trademark packages for like $1,500. I did that in November and I'm never doing that again.
Oh, wow.
It was a hot mess express, just because it was amazing because I got to represent so many people, but I literally got like 97 people at one time to buy that. And it overwhelmed my team. And I was like, how are they doing this? This is crazy. But you have to do that. Sometimes the grass is not always greener, or it's greener because they got an electric sprinkler and all sorts of stuff over there. And they got people spray painting things. So I would say nowadays you should at least have 1,500. And that's on the low end. I think we have a package right now that starts at $2,000. We also have a $3,000 and a $5,000 trademark package. And it really depends on like what you have going on. So I have, just different, it's like a different way for people to be able to see, okay, which package is best for me? Because some packages are ideal. If you've been in business for a while, you have proof that you've been using the trademark, we have evidence that we have to use, then it would be best to use our lower level packages. And it's not that it's lower quality. It's just that, okay, we have less work to do. The bigger packages are for people where we say, okay, we might have to get into a trademark battle down the road, or you're not launching your product until like the next 2 years. So we're going to have to extend or file extensions so that you can get additional time to bring forth evidence. And so some people it'll be ideal for them to go with a larger package, and one size doesn't fit all. So what somebody else did for you for one trademark, it may not be ideal for the next trademark that you have. So in my opinion, I think minimum $2,000, like $2,500. And I'm not saying that people aren't great attorneys if they offer less than that, but I think it gives you room because trademarks are filed in what we call classes. This is the best way that I can explain this. A class, it reminds me of when my big mama had the encyclopedias from 1975. And I'm like, this is the 90s, but okay, and you go to the encyclopedic volume. Lord, I don't know how young the babies are listening to me, but just go with me. It's an encyclopedia. Are they some books, y'all? I'm from the South, so I'm about to get real country. Encyclopedias are some books, okay? And each book starts with a different letter. And if you pull out that volume A, everything in volume A starts from alligator to astronaut to aardvark. Okay, all of that is in that volume. Similarly, trademarks have their own volume system, but they're not by letter, they're by number, and we call them classes. Each class houses or holds different types of products or services. So, for example, when I gave the example of Dove chocolate and Dove soap is filed in class 3. Dove chocolate is filed in class 30. So you can have different names and their products and services aren't in the same class, or they're so dissimilar that you're not going to have any confusion. Now, sometimes that's not always the case because Domino's Pizza and Domino's Sugar are both filed in class 30. And people are like, dang, I forgot about Domino Sugar. Yeah, it's a brand twin. But listen, if you want a pepperoni, whatever you want, you are not going to be like, I'm going to pick up this pack of sugar. Like, you're just not going to do that. You're going to make sure you get your pizza, right? So even though they're in the same class and they're both consumable items, they're still brand twins, and there's no likelihood of confusion because the products themselves are so dissimilar, even within the same type of channel. And so for me, the reason why I'm sharing with you about the class system, guys, is because each class costs an additional filing fee. So the more classes you file in, the higher your fees or the higher your costs. So that's why I think if you have a good $2,000 to $2,500 to $2,500, someone might say, okay, your trademark is going to start at $2,000. But if you want a couple classes, you might need to have additional funds for that, because classes can be anywhere from $250 to $350 now with the new raise in fees based on the unique things that you need. So that's why I think you need to have, just a budget for this.
I agree. And that I forgot to ask, one of the questions was about preparing your business for trademarking. Some of the things that they should have in order to trademark, like proof of use and things like that.
Great question. So we have like two different things that we say. We have a present use and future use. Now, if y'all hear other attorneys saying this, it's cool. They just took my little terms. That's all right. So because I don't like to say intent to use or use based, it's so confusing. So I like to say present use, meaning you're presently using the trademark right now, in the year of our Lord, 2021, whatever date that you're watching, or it could be future use where you say, I have an amazing brand name, but I'm not ready to use it right now. I'm going to use it in the future. Sometimes you might hear this called an intent to use application. I like to call it a future use. It just makes sense, So, if you have a present use trademark application, depending upon if you have products, you may be able to say, okay, I'm going to submit I'm a maker, I'm an artisan, I sell soap. Well, you don't have to submit a website. You can say, hey, I'm going to take a picture of the label on my soap that displays my trademark name. Or maybe you sell soap and it has a unique soap name, right? You can take a picture of that. You can take a picture and forward over a receipt, and the attorney should redact the client or the client's customer information. So receipts can work, website screenshots a lot of time, product packaging. I've seen people submit boxes, so that will work as well. Like boxes that the product ships in. If you're in a service base, you can submit business cards sometimes. I've seen PowerPoint presentations, websites that really describe the service. If you have a product and you're submitting it from a website, you got to make sure that that product has a way for when you look at it, that you can add the product to the cart. So it could be click or buy now or add to cart. You want to make sure you're displaying that button, because the trademark office is saying, okay, how is it showing that someone can purchase it when they come to the website? So ultimately, if you're in the product space, a lot of times you have to either show the product itself, show a purchase of the product, or show the means to purchase the product. Whereas if you're in the service space, maybe you're a lawyer like me or an accountant, or you're a coach or consultant, you can showcase your website showing hey, here are the different service packages, or here are the different ways that we can provide you with support, or here's why people come to us, and that will be proof. Now, if you are in the future use saying, okay, I'm not ready, you don't have to submit none of that because you ain't got none of that. So what you do, you just need to come ready when you talk to the attorney and say, okay, this is all the stuff that I want to do. I like future use applications because you are able to say, these are all the things that I want to do. And the attorney can put the whole kitchen sink in the trademark application. And then when you're ready to bring the idea to market, or you've already started making sales, what you can do then is say, oh, okay, well, all those things all the 50, 11 things, as we say in the South, that I said I was going to do, I just want to do about 2 of them. The attorney can delete those things from the application. You can never add additional products and services to a trademark application, but you can remove them. So that's why it's good. So when you're in the present use space, the trademark office is now very picky. If you put something in your trademark application, they're going to want to see proof of all of it. So you better make sure you have proof or a means to provide proof to all of it. Back in the day, I could throw a whole bunch of stuff in a trademark application. They would look at one piece of proof and they wouldn't care about the rest. Now they're looking at everything. So you have to just be prepared.
Yes, I think I remember like putting a lot of future use things, and we were going back and forth on my process. So yes, you're right.
Mm-hmm.
And I know people who are listening, if they wanted to work with you, I know you do a lot of things with the Creators Law Firm. What is it that if someone was interested in working with you, what is it that you can help them do?
Ooh, yes. So we can do a whole bunch of stuff now. So our flagship service is Trademarks. So a lot of people come to us for that, but we also do a variety of other things. So we can assist with the sale of your trademark. So I'm assisting a client with that now, who someone is coming to her to purchase her trademark. So we're assisting with that. Trademark licensing or intellectual property licensing, which means that you have a trademark or you have a unique program and an institution or someone else wants to use it. We can help craft those licensing agreements. We also help with business formation, restructuring, and reincorporation. We work with some of the other people in your team, such as accountants and things of that nature, to create unique plans for you. We assist when it comes to legal defense services. I've had to really assist some of my clients when it comes to talking with their people who are disgruntled or they're demanding refunds and things like that. And we have to step in and really kind of help on that end. We also do, I think I'd say, copyright registrations, copyright licensing. We also assist when it comes to defending, like responding to trademark office actions. Office action is a letter sent from the trademark office saying, hey, something's wrong with your trademark application, and it might be procedural in nature, or something is, I don't want to say more sinister, but something else is going on with the application, and they say, we're refusing registration. And we can craft arguments, hopefully in support of getting your trademark registered. And so we help people in that regard. We also handle some cancellation and opposition matters. So someone says someone else registered a trademark and they should not have been able to. So we assist when it comes to that particular process.
Love it, love it, love it. So, Attorney Davis, you have been on it, and I know I want to know, what are some of the tools and resources that you use, your favorite tools and resources that you use in your business or as a business owner that's really helped you propel your business forward, or you can't live without?
Oh, I love that question. There's so many things. Okay. Things that I absolutely cannot live without. I think Slack. I talk to my team so much on Slack, and I love it's like real-time communication. We're able to support one another. I cannot live without Zoom. Okay. And like Zoom has been clutch this year. So I love Zoom. I also love Loom. I love to send, we do a lot of video recaps and video walkthroughs for our clients, and clients really love those because it allows them to hear you. Because sometimes going back and forth by email, that's not great for everyone. They prefer that. And so I love the different ways that I can communicate with clients. I'm now also transitioning to HubSpot from Dubsado. I'm really impressed with how HubSpot is able to really capture things. So if a client calls, it's able to record the call, or it's able to really attach that call to their file. We can pull in things like when I have my business development representative who really helps us in sales, she's able to customize emails to clients. So I'm really excited about how we're going to be able to deliver service at a higher level. And in Canva. I'm actually been fired from using Canva this year, though. Like my creative director was like, I hope you got it out of your system. You're no longer.
Oh, wow.
Was I that bad? And she was just like, you're just doing too much. You don't, like I said, I need to focus on the CEO stuff. So I was like, that's fine. I don't care. You didn't hurt. I'm fine. But I love Canva because it's so easy to do things. So those are some of the great tools that I cannot, really live without. And I also think my team is a tool. Man, my team, like, they're so amazing and they really care about the clients. They care about the work that we do here. And so just being able to work with them, I'm actually going to, in an hour, we get on Zoom all together and we shut down the office. And what I mean by that is I make them stop working because they work too much. And as an entrepreneur who works from home, like all of us are doing, it's really hard to say, oh, I'm transitioning from work to home because your work is in your home. Yes. So we are able to come together as a team, answer any last minute questions, send those last minute emails. I like to call myself DJ Sweet Tea. So I take, I take music recommendations. So I'll play some music for us and stuff like that. And so it's a really great way for us to come together and like say, hey, we did a good job today. Now it's time for us to relax and spend time with our family.
Yes. And your team has been great in communication with us. So yes, I agree. That comes from being a great leader. So yes, kudos to you.
Thank you.
And so how can people connect with you, support you on what you're doing, and follow and contact you?
Thank you for asking. One of the best ways to connect with me is on Instagram at my name, Ticora Davis. I'm going to be really building up my personal brand this year, and then also at Creators Law Firm. And it's going to be awesome because now you're going to start seeing the team behind the scenes. We're going to start doing some lunch Q&A. So I'm really excited about all the amazing things that we have in store. So to stay connected with me, I think Instagram is a great place to start. And then we can go from there.
Love it, love it, love it. Well, Attorney Davis, this has been amazing. This has been an amazing masterclass. I almost want to charge to listen to this. I'm like, should we do a Patreon or something with this? It has been amazing. I've learned a lot. I'm pretty sure my audience will really appreciate it. So thank you for being here and supporting us as we support you.
Oh, no, thank you so much for having me. I'm so honored. It means a lot. I shared my story in the beginning, just really starting and not knowing a lot and being able to build this by the grace of God. And it really means a lot when anybody asks me to lend my voice and my expertise on this matter, especially something I'm so passionate about. And I really just appreciate you guys for recognizing that in me and seeing something in me that you think would be a benefit to your platform. So thank you for the opportunity.
You're welcome. And one thing I will say before we head off is that you really do well, and people, you have to go follow her because you really do well. I think a lot of people can learn from you is focusing on your niche and being the go-to. So yeah, great job in doing that. And we appreciate you. So until next time, everyone. Listen, I told y'all I wasn't exaggerating. Wasn't that so good? Like, it was so good, I almost wanted to charge to listen, but y'all are family and we couldn't do that. But on a serious note, we know that running a business isn't easy and there are always things to do. But you want to set a proper foundation and avoid as many pitfalls as possible. As Attorney Davis mentioned, you want to protect your business and your sanity. And legal issues is not something that anyone wants to deal with. So if you're strapped for cash, check out some of the free resources mentioned. If you need to speak with a professional and it's within your budget, reach out to an attorney like Attorney Davis. And as promised, check out blacktobusiness.com/44 to get full show notes and links to the resources mentioned in this episode. And since we didn't charge y'all for this masterclass, please support us by simply leaving us a review on Apple Podcasts and sharing our show with a friend. Thanks, guys, so much for listening, and I hope you took away something from this episode. And until next time.